So good afternoon and welcome. My name is Debbie Moore. I'm part of the team at Advisors with Purpose. It's my pleasure to welcome you today and say thanks for joining us. The webinar today is called Live Well, Plan Well, Leave Well. It's hosted by Opportunity International Canada, and we really thank them for inviting you to join us today. And we all look forward to learning together about this really important topic. So we're going to jump right into it. And I'm going to invite Daniel Jeanette from OIC. He is the VP of Philanthropy at Opportunity International. He's going to give us a few words, what's happening, what's new there, and then he's going to introduce our speakers. So over to you, Daniel.
Thanks, Debbie. Hello, everyone. Such a pleasure to be with you today. As Debbie said, my name is Daniel Jeanette, and I serve as Vice President of Philanthropy with Opportunity International Canada. I'm joining you all from sunny Calgary, Alberta. It's actually a nice, really beautiful day and kind of warm today, so we're quite grateful for that. And I want to welcome all of you around the country who are joining us to learn a bit more about strategic financial planning and stewardship through our wills and estates. I'm thrilled that so many of us are on the line today. I know that many of you are ongoing partners and donors of OIC, and I'm always grateful for opportunities for us to join together with like-minded people. And even though we can't all see each other on this call, you can rest assured and know that there are many of others just like you with common interests who want to see the world change for the better who are on this call. At Opportunity, our mission is to see people empowered to work their way out of poverty with dignity and with purpose. And we do so by offering access to capital and financial services in the forms of microloans, training, such as financial literacy, budgeting, financial management, and so on, and support along their journey so that we can ensure their success on that journey. Lives are transformed when people, especially women, gain stable sources of revenue, and they can in turn invest that into their families by providing food, keeping their children in school, having access to healthcare and medication, and so much more. This year, it's our 25th anniversary, and we're celebrating in a big way with the visit of some of our international partners to Canada. This week, we're privileged to have our friend Diana Montoya from Nicaragua. She's the executive director of our partner at Asodenic in Nicaragua, and she's sharing, or she did share last night in Victoria, BC. This week, again, she's going to be sharing in Vancouver, and later this week in Calgary. And then in just a couple short weeks, our partners from Colombia will be here as well, and they're going to be sharing at gatherings in Toronto, Calgary, and Edmonton. So if you'd like to, or you're interested in joining any of our events in those regions, and you'd like to meet with them or meet with us and some of our partners, I'd really welcome you to reach out to our team at OIC to learn more about the dates and the details around some of these events and these visits. Because of the generosity of a lot of people like you on the line, we're thrilled that this year we've been able to impact, like every year, millions of people around the world. And this year it's really been no different. We've expanded some of our programming in countries like Ghana and Nicaragua and Colombia, and we're able to reach more and more people living in extreme and ultra poverty by providing them with the support and the help that they need as they work their way out of poverty with dignity and purpose and for good. I was just in Colombia last week with some of our donors and partners, and one of the things that we were discussing was that it can take some families an average of 11 generations to exit poverty on their own without the support of an organization like OI. 11 generations is a really long time. But with our model, providing a small loan, some training, and some support, they can often leave poverty behind for good and in a sustainable and dignified way within one generation. It makes an absolutely huge difference in the lives of the people that we're serving. And so we benefit so much from the incredible generosity of our donors, many of you, which you are. And we want to thank you for your partnership and your generosity that allows this work to happen. So today, this is kind of our chance to give back to you. We've been working with Advisors with Purpose for many years, providing free webinars and information to you about estate planning. There's no fee, as you know, to participate today. And we're grateful for this wonderful partnership that we have with AWP, and we're excited to introduce you to their team and to hear what they're going to share with all of us today. So thank you for being here. We hope this brings a lot of value to you. And at this time, I'd like to pass it on to Lauren Jackson, the President of Advisors with Purpose, to take it away, and you'll hear from Lauren and Mary Lynn as well today. Thank you so much, everyone, for being here.
Well, thank you, Daniel, and thank you all for joining us. Great to have you on board, and I see some people there from Canmore. I was in Canmore we took our family out there. Actually, I talk oftentimes at these things about having a family meeting to talk about your estate plan with the family. That's where we did it, was in Canmore. So yeah, great place to do that. Very beautiful location. Well, let's get into this. I'm going to go the first part, and then Mary Lynn is going to join us a little later on, and then I'll kind of wrap it up at the end again. So let's get going. A little bit about who I am. I've been around in this business for a long time, as you can probably tell by the look of me. But I left the for-profit world back in 2001, and I call it, I didn't retire, I rewired. What do I mean? Using the skills and abilities that I had from my previous occupation in financial planning to help people, give it away. I like to say I spent the first part of my life helping people accumulate wealth, and now I help them give it away. Yeah, to their kids and charity and where else they want to give it. So I started the Canadian National Christian Foundation, and then a year later, after I retired or rewired, and still serve as a volunteer at the foundation yet today. And then the estate planning work that we're doing with Opportunity International, I love connecting with Opportunity. I've been involved with them for many years, but we've been doing this part for 13 years now, and helping Canadians right across the country think through and know about things they need to know about in their estates. It might also be important for you to know who Advisors with Purpose is, because that's the name we work under. It actually is a ministry of a charity that we registered called Financial Discipleship Canada. And we offer estate planning to the donors of many charities. We don't sell anything. So Daniel already talked about how there was no cost for you to be on this webinar. There is no cost. We're not trying to sell you anything, and we don't do wills. We can help you get to a lawyer to do a will, but we would do the plan. And now you're going to be wondering, so what's the difference? Well, we'll get into some of that in a bit, but this one's probably even more important. Not only is there no cost for you to be on this webinar, there's no cost to you to use the service. Why? How can you do it for free? Well, we can't. Opportunity International actually pays us to provide this service. And just as Daniel said, he nailed it. The reason they do this is to say thank you for your support of Opportunity International. So I think that's a very nice way for them to do it. And by the way, their cost does not change if you use the service or not. So why not? Yeah, find out. So speaking of planning, let's take a look at what some people, some names we've known have talked about planning. Ben Franklin said it this way: by failing to prepare, we're preparing to fail. Dwight Eisenhower, former president, said, plans are nothing, planning is everything. I really like this third one. This one's my favorite. Planning is bringing the future into the present so that you can do something about it now. That's really what we want to be doing. And estate planning is bringing the future into the present so we can do something about it now. So what is an estate plan? It's just that. It's a plan for the most tax efficient method to distribute your estate. And if we don't know what the rules are in estates, we might very well make some mistakes we didn't know we were making. And it just helps us think through the impact of our giving as well, and how much we're leaving to our kids. And I usually find out that or people find out there's a lot more being left to their kids than they thought. And is that going to help them, or is it going to hurt them? Those are some interesting questions. So without a plan, we may miss things because, as I say, we didn't know what we didn't know. And an estate plan can help, as I said before, bring the future into the present. And I love that because it's just thinking through. So when we graduate from this earth, what are we leaving behind? What is it going to look like? And how are our kids going to react to that? So those are some important things to think about. So now versus later, what do I mean? Well, 58% of Canadians do not have a valid will. So now, meaning let's get it organized, get things organized now rather than waiting until later. 58%. That always baffles my mind to think that over half of the Canadians don't even have a valid will. And as you can see, that's a Google survey that was done in 21, so it's not that old. Keep it current. In that same survey with Google, 10% of Canadians don't even haven't updated their will. They haven't kept it up to date. So in other words, and I'm surprised it's only 10%, quite frankly, because I often talk to couples that will say, well, you know, we have been looking for a long time about doing our will, but we still have a guardian for our kids. Well, how old are your kids? Well, they're 35. Well, that's not going to work well. So yeah, it's at least 10% of Canadians need to update their will. So mistakes often come from lack of information. I think if most of us understood all of the situations with, we would be way better at managing our estates, but we may lack some information. So 70% of estate transfers fail. What in the world is that about? Well, Forbes magazine did a survey and they found that when they talked to the beneficiaries of the estates, that it didn't work the way mom and dad had planned 7 out of 10 times. Wow. How could it be so bad? I think it's that bad because they didn't have a plan. What about tax in my will? Well, your estate may have one more beneficiary than you planned for. That's the problem. We don't have anything we call estate tax in Canada, but we call it other names, but it's still there. It's capital gains tax, it's tax on interest, it's income tax, it's all those other names that we have. But so people do not often think about some of the tax perhaps in their estate. And it might even be their RRSP is a tax problem if you have an RRSP or a RIF. But there are really 3 primary ways to pass assets to the next generation. Actually, there's 4, but I'm going to primarily focus on the 3. We'll talk about the 4th at the end. So, but 3 primary ways. What are they? Well, the beneficiary designation is the first one. And if you have an RRSP or a RIF, you'd know about this one. If you have life insurance, you'd know about that because you'd have a named beneficiary. If you have a tax-free savings account, hopefully when you set it up, whoever you set it up with, had you set up a beneficiary for it. Segregated funds have a named beneficiary. What is that? Well, it's actually a mutual fund, but it's managed by a life insurance company. So if you have a normal mutual fund with one of the big mutual funds companies, they don't have named beneficiaries, but segregated funds do. Now, let me just put a caveat in here for all of this. If you're in the province of Quebec, you're not used to using named beneficiaries, but in the rest of Canada, we do. So other than for Quebec, what I'm saying here would be correct. You can have a beneficiary designation on any of these things, and the money goes outside of your will, by the way. It goes directly to them upon your death, and they're now receive these funds rather quickly, quite frankly. Compared to having to go through your estate. Well, then the other one would be joint ownership. Yeah, you could own your house together. My wife and I have our bank accounts in joint ownership. All of that stuff is in joint ownership. Now, you might be saying, well, I want to have my son or daughter as a joint owner. Would that help? Well, it could, but there is some risk if you do that. Of course, you need to remember that if they have access to your bank account, they could withdraw the money. They could also use your bank account as collateral to get a loan, and you maybe not even know about that unless they defaulted on the loan, and then of course you'd find out the hard way. So so you need to be aware of that, but it could work. It's an option for sure. But both of these bypass your estate. So something happens to one spouse and the surviving spouse now automatically owns the house. Yeah, that would be normal. Just don't have your kid owning the house unless your kid is living in the house with you, because then we get into that primary dwelling kind of thing, and that doesn't work real well if you have your child on it. What's the third one? Well, the third one is through your will, everything else. And it pretty much everything you that is not gone in those first 2 is going to show up in the third one in your will. Unless we do number 4, which happens to be my favorite. Do your giving while you're living, so you're knowing where it's going. Yeah, that sounds and rhymes nicely, but it's a great idea, actually. So you could give to your family and charity now. What do I mean? Well, we helped our kids. They're not getting much out of our will. They know that. We've told them that. In fact, that's where we told them when we were in Canmore. But we have 2 kids, and they're both married with 2 kids each. So we have 4 grandkids. We had them all there in Canmore, and we had a conversation about our estate. Here's the thing. I would rather help my kids when they were getting their mortgages paid off and my grandkids through Christian school than I would leaving it to them at the end. So we just chose to help them now. And the other thing is, by giving to charity now, I get to see the charities benefit from it while I'm still alive. So a very important question to be able to do that, though, is to know the answer to the question, how much is enough? How much is enough to retire on? How much is enough to leave my family? What's the right amount? And then how much should I leave to charity? What percentage, perhaps, of my estate would I be doing? And then if I've got that figured out, what would be the best asset to leave to charity? That's a great question. I remember a couple that I talked to at one of the presentations I was making, and they said, you really helped us, because they said we couldn't get our will done for 2 years because we were stuck. We didn't know what would be the best assets to give to charity. We knew we wanted to give, but we weren't sure which ones to give. So those are the kind of things that we can help you with. And those are very important questions, obviously, when it comes to our family and the charities that we want to support. Well, let's change gears a bit and talk about your executor. This is a very important role, by the way. This has got a way more complicated and important than it used to be. We changed the rules back in 2014 and kind of messed things up for executors and made them a lot more accountable, but that can be good too. So the first thing I would say is they need to be a Canadian resident. So if you have one of your children on as your executor and they live in the US, just know this. That means that the US tax laws and rules will be in play in your estate. You really would probably not choose that. That would not be the best choice. So you need to choose a Canadian resident. And what else? Well, they have duties. Here's their duties. If you haven't already prearranged your funeral and burial arrangements, then that's their responsibility. They need to determine all of the assets and liabilities, and they apply for probate if that's required. They would be collecting and protecting the estate assets, paying the debts. Yeah, any debts or taxes that would be due, they're responsible for that. And then distributing the estate. So do they know what the rules are? Yeah, there actually is an executor's code of conduct that they will be held accountable for by the courts. And that happens this way. They have a duty to follow the terms in your will. So I was asked that one time in one of these, well, what if they don't follow the terms? Well, they have to, because if they don't, the beneficiaries could go to the courts and make that happen. They have a duty to treat all the beneficiaries fairly. They can't delegate these duties to somebody else. No, that's not going to be allowed. And they have a duty to avoid the conflict of interest. So they can't be paying themselves first, some kind of self-dealing deal where I'll pull this out and take it for myself and we'll pay the other beneficiaries later. No, they can't do that. They have to maximize the value of the estate. What do I mean by that? Well, I mean that if the estate has real estate in it, for example, then they have to make sure that real estate is taken care of. Make sure the lawns are mowed, the air conditioning or heat is on, making sure that the property is well groomed and taken care of. So all of those things are the responsibility of the executor. And if they live in another province, or even worse, another country, which I would highly recommend against, but if they did, you can see how difficult that might be. And then they have a duty to account for everything that was in the estate and where it went. And they have to report that all back if they're under Under probate, they'd have to be able to prove that to the courts. So if your executor wants to protect themselves, here's some things they need to think about. And by the way, if you're wondering, oh, I'd like to have a copy of this for my son or daughter who's my executor, well, as Debbie already said, you'll be getting a copy of this later, so you can always send this to them to have a look at. But as an executor, they need to be demanding timely answers from the professionals that they're dealing with on the estate. So the lawyer or accountants or others that are involved, they need to be pressing them for timely answers, not letting this thing drag out. They need to read every document careful before signing, make sure they know what it says, and never, ever sign an incomplete document. Of course, none of us should ever do that. Even if somebody's trying to rush us to get that done, I just refuse to do that. In fact, sometimes I get documents under my role at CNCF that I need to sign, and people will not have completed the document, and they'll send it to me to sign. I go, no, I'm not signing that until you complete the document. And then keep an estate diary of all the meetings, the phone calls, even the points that they covered in a call or a meeting need to be recorded, because if things go wrong, you're going to need proof of what was said and done. And then keeping copies of all emails, all invoices, receipts, all of that kind of stuff, so that that's all tabulated up at the end for the finalization of the estate. And then they need to keep a record of all communications with institutions like the banks and stuff, because you'll be running around to banks and credit cards and all those kind of things that you need to stay on top of. So they can protect themselves. Yeah, there is a way to do that. There's an insurance that they can go to. It's called ER Assure or airassure.com. And there is a fee for that. Of course, it's a small percentage of the estate, but it's usually a couple $100. So it's not it's a very small percentage of the estate, but it protects the executor. And I think if I were dealing with a huge estate or even a reasonable sized estate that's more than cash, let's say it's got real estate and other things in it, then there's going to be probate very likely. By the way, I often get asked that, when is probate required? Well, it's required whenever the holders of the assets decide it's required. If a bank says, I want probate for $5,000 in an account, then you may be forced into it. But for sure, if it's real estate, it would probably be probate. And if there is over 50,000 in the estate, oftentimes it's probate. So, but that's the insurance that an executor could have that protects them. Well, let's change gears again and talk about something different. What about a trust? Would a trust help, or do I need a trust even? You may have heard of people talking about, oh, I don't have a will, I have a trust. Well, they kind of misuse those names sometimes, but let's just take a look at it. So in Canada, you can't leave money to a minor, or it would have to have a public trustee or guardian to manage that money. So if you have underage children, then you'd want to have obviously a trust set up for them, and guardians, and maybe a trustee over the money would be two different people. So yeah, that would be one thing. What about a disabled child? Well, if you happen to have a disabled child, then and you leave them money in your will, the problem is that it could remove them from the provincial assistance, because the provincial asset test would kick in. But if you set up a Henson trust, then that's a workaround for the provincial asset test. So that would solve your problem and allow you to leave money to a disabled child without upsetting the amount they're getting from the provincial government. What others? Maybe a spousal trust would be appropriate. Well, when would you use a spousal trust? It could be that you may have a spouse that says, I don't want to have to manage all that money. I don't know what in the world, I wouldn't know where to invest it, or I wouldn't know how to deal with it. Okay, maybe a spousal trust would be a good way to deal with that. Or if you're concerned about family members wanting to borrow from the widow or widower after you're gone, would maybe a spousal trust protect that? Yeah, that could be a good choice. And usually income from a trust, so a spousal trust, for example, would go to your spouse until until your spouse's death, and then the remaining assets would go to the next of kin. So you would specify that in the trust. For example, maybe it goes to your kids, or if it's a second marriage, they may go to your first marriage kids and not to the second marriage kids. I mean, there's all kinds of things you can do with a trust that way that could help in transferring those assets. So if we're planning now, this is kind of the live and help for now rather than waiting until later. But if we're planning now, that will help our heirs. That will make things simpler for them. Remember, it's a very difficult time for those who are left behind, and your planning now can help them through those mourning stages. I can't imagine anything worse than coming into a situation where you've just lost your mom and dad, and you find out there was no will, and you got this mess of, I call it a snake's nest, trying to clear out what in the world, who owns what, and where does it go, and where is it? How are we going to deal with this? And you'd be months, maybe years getting it settled. So it's important to deal with those things. So here's some examples again as well. Personal effects. You may want to specify how your belongings should be divided. You know, for example, if you have one child that wants your Tesla and the other one is going to get a toaster, it's a little bit funny to make my point. But you may want to allow payments to the one that's getting the toaster, because quite a difference in those two, obviously. We might, if you're giving to younger beneficiaries, and younger could be not necessarily a numerical number. It might be where they're at mentally, like are they mature enough to manage a lot of money yet at this point? Some are very mature at 18 and some are not very mature at 38. So you know your kids better than I, but maybe staggering out the money that a person receives from an inheritance gives them an opportunity to learn about the money management before getting the big bucks. So rather than give them a big lump sum. And let me bring in here as well, I was making a presentation the other day, and there was a couple in the room that had a daughter that was a bit of a spendthrift and had blown through a lot of money in a short time. And I said, so how do you have your will set up? And they said, well, we have it set up that 1/3 goes to each of our 3 kids. I said, so you're giving her a third? Yeah. Well, how will that work? Will that be good? No, that'll probably hurt her, but we didn't know what else to do. Well, there are things you could do. And so that's what some of the things, kind of things we can help with. So just a couple other things on good planning. Funeral wishes. The more guidance that you can provide, I like this, the less money will be spent on things you don't want. Yeah. And there'll be a lot less stress for the people making those decisions and fewer complaints from the rest of the family because you already made those decisions. My mom and dad had that all set up, where they wanted the funeral held, what songs they wanted sung at the funeral. It sure made my job a lot easier as the executor. And then resolving deadlocks. If you have set it up so that you have multiple executors, and sometimes people do that, maybe you'll want to pick someone else to break the tie if you have an even number. Or if your kids just can't see eye to eye, maybe pick a non-family member as a co-executor. So just some things to think about and preparing. And then last but not least, treat them uniquely. I always say, are you treating them equally or uniquely? And that's what I was referring to when I talked about the couple that had the daughter that was a spendthrift. They need to treat them uniquely. Yeah, 2 of them, they can give them a lump sum. But the third one, if they gave her a lump sum, it'd soon be wasted. So in that case, then the one child could be set up in a trust so that they're receiving this money over a period of time and they can't just blow through it and be hurting them. So those are some things to be thinking about. So let me stop there and turn it over now to Mary Lynn. And Mary Lynn is going to take us through the next part.
All right, here we go. Thank you, Lauren. All right, so I'm Mary Lynn Huizinga. I'm an estate specialist from Alberta and part of the team here at Advisors with Purpose. So I have the privilege of doing will and estate planning with people all over Canada, helping them to protect their assets, ensure their wishes are honored, and provide for the people and causes that they care about. Do you need a will? Well, recently, friends of ours lost their brother to a sudden cardiac event. Such a shock and a heartbreak. And they've had the task, our friend has gone over to search his brother's home for any indication of his wishes. And they haven't found anything. Very stressful, they're worried because they think, things could get missed. And it really has added a lot of stress in a time of loss. If no will is found, they're still looking, of course, the government has a plan for how his affairs will be wrapped up, but it's unlikely it will fully align with his wishes. So consider, if you have any minor dependent children, if something happens to you, who will care for them? Your will is your opportunity to name a guardian. Your province will name one for you if there is no will, but how much better to be the one to make that choice. Also, you can choose your executor. Lauren discussed the considerations for this role. You probably have the best idea who you could trust to take on that task. And consider your assets. Your will allows you to arrange the orderly transfer of assets to your heirs and to your chosen charities that you wish to receive them. And you're in control of that. Without a will, the government makes those decisions for you, generally shaking the family tree and after paying the taxes and liabilities. And this can be particularly problematic for blended families or for common law spouses. It rarely gives you the desired outcome. Additionally, charity is never part of the equation when the government makes the decisions. And it's most unfortunate, really, because in the year of your passing and the year prior, 100% of your tax liability could be offset through donations to registered charities in Canada. So while paying our taxes is important, most people would prefer to continue their giving legacy by giving to a cause that is closer to their hearts. And what a privilege to be able to do so while still blessing our descendants. We're talking about planning for leaving well today. Last year I was at a funeral and ran into a good friend, and she was telling me about the difference between her parents and her in-laws and when they passed away. And her in-laws had planned everything. They had prepared everything. It really alleviated stress in what was a time of grief and loss. And her own parents didn't. And that was a nightmare. And she said, boy, oh boy, we have everything in place because we want that gift for our kids. So when you're considering how to leave well, make a plan, put things in place, and review regularly. Another consideration in good planning is, in living well, is having your substitute decision maker in place. So if capacity is lost for some reason, having your documentation in place saves time and money for your friends or family members because they don't have to go to court to get the authority to act on your behalf if that's ever needed. So consider thinking of somebody who is trustworthy, who is capable, and geographically reasonably near to you. You will need 2 documents. The enduring power of attorney, that's for your financial affairs. And there are some limitations and there are some responsibilities. They can only do things that you would normally do. So they can't start their own personal vacation fund from your bank account. They cannot change your will, but they can manage your bank accounts. They can pay your bills, sell and buy real estate depending on what your needs are. They can deal with your business interests. You can limit the power of attorney for specific powers for that. And they have an obligation to act in your best interests. Then there's also a personal directive for your personal care, also called a representation agreement. I think there's a different name pretty well all the way across Canada. Sometimes it's called a living will. This gives someone the authority to make healthcare decisions on your behalf. It can be end of life decisions. That's what we always think of, who decides when to pull the plug, but it can be also ongoing care, like healthcare, medical treatment, your hygiene, your safety. So this is a chance. If you put this document in place, you can talk to the person you're considering for the role. You can share your values and help them to guide them, even if they ever are called on to make these types of decisions on your behalf. So make sure that you think about it, talk to the person you're considering or the people, right? Because it's good to have an alternate, and ensure that they understand the role and they're okay to commit to that. And then also let them know where those documents are so that they can access it if it is needed. What about joint tenancy? Lauren touched on this briefly. You know, people will often ask about, should I make my home or my cabin or cottage, should I make it jointly owned? You know, and that is something that it's a difficult decision. It can work, absolutely, but it can also cause some problems. So it's really important to consider it very, very carefully, because once you've added someone as a joint owner, you can't just take them off because they're also an owner now, right? It's not that simple. And there can be tax considerations for sure. And another risk is, of course, that that if the person that you've made a joint owner has a creditor situation, your property could be at risk because of that. Additionally, if they're married and there's a marital breakdown and they own your home as well as you, that could be problematic in terms of the division of family property. So you really want to think about this carefully and think about all the risks and the benefits. What about talking to your family? Lauren mentioned a family meeting that they did out in Canmore. That's excellent idea. You know, when we're talking about planning well and leaving well, and in the very best way to ensure that your wishes are honored is to have clear communication ahead of time. Set the expectations. You don't have to share dollar values. Those are going to be changing over time anyways, but sharing your hopes, sharing your heart, sharing the general plan will go a long way towards ensuring that your wishes are honored and that your children can still be friends when the dust settles, you know? So how do you facilitate that? Family meetings are a great opportunity to build that connection. So my family, we're in business together. My dad started a business many years ago. And so we started family meetings over 20 years ago already, and we hired a facilitator, someone to work with us. And it was very helpful because the facilitator set the agenda and promoted good communication. And that allowed my parents to participate without having to lead the meetings. And there was a neutral third party in the room to create that felt safety. And the conversations were very effective. So we've been able to continue that over the years, and we don't always use a referee, I mean, a facilitator, but over the years, it's been very helpful. So another thing to keep in mind when you're thinking about your estate, you're not asking permission from your family because you have the decision-making authority and the responsibility to steward your assets, of course. But if there is no communication at all, there will be surprises at the end of life. And typically, the only ones who benefit in that situation are the lawyers when everybody starts fighting. So how much better to intentionally plan ahead and communicate and get everyone working together as a family? What about your vacation property? This one's a real hot topic. It's very emotional, very personal, because this is where memories are made, right? This is a sentimental place. So this planning depends on your goals, and it's really going to be important that you talk to each other, talk to your family members about what your goals are and what you would like to see happen here. So keep in mind that as a secondary property, there would be capital gains tax on any growth in the value of your vacation property. unless you were to give to charity to offset those taxes, which is an option we could talk about. One thing that many families do is put some life insurance in place. We don't sell anything, of course, but that's a tool that people use to make sure there's the cash available to, give to charity, to pay those taxes, whatever needs to do to keep that vacation property in the family. And something else to consider if you're thinking to keep the property in the family is considering a use agreement of some kind, thinking about the maintenance, who's going to pay the maintenance, what's that going to look like going forward, and who gets to use it and when, and getting everybody on the same page with that. A good friend of mine, when her parents passed, they gave the family cottage to the kids to share. And that worked well for a year or two. And slowly it dissolved and it got very difficult because they didn't have a clear understanding of how this was supposed to work going forward. So it's really important to talk about it to keep everybody on the same page. Another consideration is, where is your cottage located? If it's the real estate is governed under the laws where it's located, because it's not something you can just pick up and move, obviously. So if it's in another country, you may need an additional will in place. There are some other considerations to keep in mind. So as you can see, there are several things to think about when considering the future of your vacation property, and we can talk about that. Lauren, back to you.
Okay. Where did we go? Okay, I think we're ready. Oh my goodness.
You good?
We're good. All right. That's so that's where I ended up, and then we had Mary Lynn. By the way, you can see the difference between a woman's touch and a man, right? When Mary Lynn put her slides up there, I'm like, oh my goodness, I want her to do my slides next time. These are PowerPoint slides we're using, and hers are much prettier than mine. Mine are just facts. Give me the facts, ma'am. But she's got all those pretty pictures and families and cottages. I'm jealous. Yeah. So I think next time. And by the way, wouldn't you love to have her helping you with your estate plan? She has such a great way about her and helping you think through those things. So help is available. And Mary Lynn is one of the advisors that you could be working with for sure. So remember, it's complimentary. There is no cost to you for this. Sometimes if you don't have a will, I find people are saying, well, it's too expensive. Well, let's knock that one out of the way, because if you went to www.legalwills.ca/AWP, by putting the /AWP on the end, you get a reduced cost. But for less than $100, you can do double wills. You could do, and the way that works is you go on that website and you answer questions, and it prints off your will when you're finished. It's pretty straightforward. It works really well. My wife and I did our will at the lawyer's office, but I did go through this one to try it to see how easy it is, and it's very intuitive. It works very well. And then you can take it to an attorney or somewhere, or a notary, and have it witnessed. So now what? Well, remember, back in the beginning, I talked about how the Forbes survey said 70% fail, and we don't want that. We're here to help you. There's no cost to you for this service, and nobody's going to try to sell you something. So I can't imagine why you wouldn't choose to do this. So we just want to help you make better decisions so that your family will have fewer disappointments and bad surprises at the other end. So within the next few days, we'll contact you. Yeah, you don't have to know where these guys gone to. So Tanya Rust is the lady at our office that will reach out to you. So it will look like that. Trust at Advisors with Purpose. You can trust. That's for sure. But the reason it's trust is it's Tanya Rust. And all the meetings are by phone or by Zoom. So no, unfortunately, Mary Lynn won't be coming into your office or your home. You'll have to be coming into her home by Zoom, but she'd be happy to help. And we have other financial advisors standing by as well. All of them, as I said, all the meetings are by phone. There's three-step program. What is that? The first one, just getting to know you. Do you have kids? Do you have grandkids? Where do they live? All that kind of information. Then we get into the planning process. Do you have RRSPs? Do you have a cottage? Do you have you own your own home? All those kind of questions. Do you have investments outside of that? Do you have a TFSA? Which, by the way, happens to be one of my favorite to give to your kids because it can go tax-free. So yeah, that's a good one. And then implementing your plan. We'll walk through it with you, helping you implement that plan so that you can now take it to your lawyer, have your will redone just the way you had talked with us about it. So here's how it works in final. It's confidential. None of this information is given to Opportunity International or anybody else. This is between you and the estate planner. It will be very personal to you. Will help you think through the preparation of updating your will. And it will for sure be focused on the most tax efficient method of doing that. So let me stop there. And Debbie, do we have any questions?
Hello, Lauren. Yes, we do. And thank you so much. Thank you, Mary Lynn, as well. Before we get to the questions, I'm just going to invite Daniel back on quickly before we lose anybody here. So Daniel, just say a couple of last words and then we'll get right into our questions.
Absolutely. Thank you. Well, yeah, I know that some people, the time might be tight today. And so before we go into the Q&A, I just want to thank everyone for joining us today. I really hope on behalf of OIC that this session was informative and can provide you with some of the peace of mind that you're looking for in your own planning. And knowing some people that have worked with AWP on their own personal estate plans and everything, I highly encourage you to book a time with Mary Lynn or one of their advisors. It'll really be of great benefit to you, I'm sure. So I want to thank Lauren and Mary Lynn and Debbie as well for another great informative session. And I just appreciate you all for being here. So if you have to go now, we say goodbye, but hopefully most of you can stay on and get the answers you're hoping for from your questions. Thank you very much, everyone.
Excellent. Thank you, Daniel. Very good. Okay, so yes, we do have a couple of questions, Lauren. And Mary Lynn, so either one of you can jump in. What does the executor need to be protected from? You said during the presentation, the executor might need protected. Why would insurance be needed?
Well, if there's a mistake made, if the executor makes a mistake and gives the money the wrong amount or to the wrong person, or I've seen this one happen where they gave all the money out, they thought they were all done. And then CRA comes back and says, oh, we just realized we paid you in Ontario, we call it the trillion benefit. So you got to pay that back. Or we missed, we need the tax on the RRSP, which we didn't get 2 years ago when you closed out the estate. Well, they're going to be held accountable for that. The executor will be. And the insurance helps protect them against those kind of errors. If they do something dishonest, it's not going to protect them, but that's not what we're looking for. So it's kind of an error insurance. That's what it is.
Yeah, good. When do you turn? Where do you turn to? Let's try that again. Where do you turn for an executor if you don't have any family or friends you feel can handle the job? Where would you go?
Mary Lynn, you want to take that?
For sure. Great question. So there's a couple of options. You can look for a professional executor, and sometimes your lawyer will do it. Most financial institutions offer this service. I have heard that can be somewhat impersonal. So consider having a family member or a friend or somebody as a co-executor, potentially, if that's an option for you, but that's definitely one. And then there are other companies that do offer that service that specialize in that. And we have a connection with one that out of Toronto, the Estate Stewards, and they do a very, very good job. I spoke with Nicholas actually recently. He's the fellow to be in touch with over there. And he said, my hope and in working with families is that the kids will still be able to enjoy Christmas dinner together. And I thought, isn't that a great goal? So yeah, they do a very good job. I think Debbie posted it in the chat. So
I did.
Another option.
Oh, that's really good to know, Mary Lynn. When do you know your job as an executor is over? does government tell you, CRA, the bank, who tells you when you're done?
Go ahead, Mary Lynn.
Well, so what you can get from CRA is called a clearance certificate. And before you make your final distributions, you as an executor, you really need to have that in place. If you don't have that and you start making the distributions, you could find yourself kind of like Lauren was just talking about, you're on the hook. You are responsible as the executor, and you will be held liable for that. So once you have that clearance certificate, you can make the final distributions. And once everything is wrapped up, then you know you're done.
Good. Okay, Lauren, here's one specific to a cottage or, another property. If I set up a trust for my kids that holds our cottage, do I have to pay the full capital gain as of that date, or is there a way to crystallize that gain today and pay it when I die? Is the answer the same if I just put their names on the cottage or on the ownership?
Mary Lynn, I'm gonna let her take that one because that's an advisor's tax question right there.
Okay.
Okay, so yes, if you transfer, anytime there's a transfer of title, so you transfer the title into your trust, then yes, there would be capital gains tax owing at that time. And there may also be tax owing if you simply add the kids as owners from that time. I've heard mixed answers on that one. Lauren, maybe you could speak to that specifically, but definitely if you transferred into a trust, there would be a disposition at that time.
Yeah, and it's gonna differ by province because some provinces you're gonna have land transfer tax when you make that transfer, whether it's now or later. So yeah, probably the best way, and Mary Lynn touched on it when she was doing her presentation on the cottage, was maybe have a life insurance policy that pays the tax and then just leave it in your name until you're gone. And then when that goes to the kids, you have the life insurance that pays the tax. That's a possibly good way to do it. We do not sell it. We can refer you to a financial advisor if you don't have one, but you probably have one that you've been using, so you'd be welcome to use your own to do that, but they can help you with that.
Okay, good. Okay, that is our questions for now. So thank you. I'm going to say, first of all, thank you to Opportunity International for inviting everyone, for doing the legwork and putting out the invites, and to Steph for all her hard work, and Daniel. Thanks, Lauren and Mary Lynn. Great information shared again today. Lots to know. Just a reminder that there's a 2-question survey at the end. If you just take 2 seconds and fill that out as well, you will receive the recording yet this afternoon. So look for that, and then your follow-up from Tanya Russ. So we will be in touch. And I just see it, one comment just says thank you. So thanks, everyone. Have a great afternoon and evening. Take care.
Thank you.
Thank
Bye.
you.